under Order 2 Rule 3 of the Civil Procedure Code, if the transaction is same, Your Lordship, if the nucleus, the operation of the nucleus of operation, if it is same, Your Lordship, then Your Lordship, we can definitely put a Order 2 Rule 3 and join to personal action, Your Lordship. In this case, Your Lordship, we have, and since under Section 20 of the CPC, Your Lordship, the court has jurisdiction, Your Lordship, we have come with the basic idea that the two suits can be joined because the transaction, Your Lordship, is essentially the same. Because it is the same separator which has a particular patent, which has a particular trademark under which it is sold in the market. And it is this patent and it is this trademark that they have infringed upon. Your Lordship, furthermore, Your Lordship, I would like to state that when a patent for more than 6 years has not been challenged, there is a presumption of validity, Your Lordship. For that, I would quote, Your Lordship, the case of National Research Development Corporation of India, New Delhi versus Delhi Cloth and General Mills Company Limited and others, in which it was clearly said, Your Lordship, if the patent is more than 6 years old and there has been actual user, it would be safe for the court to proceed upon this presumption that the patent is valid. Your Lordship, this is to further show the fact that we have come with a prima facie case, Your Lordship. There is a prima facie presumption that we are the holders of the patent, because for more than 6 years, Your Lordship, we have been holding this patent, and not just that, Your Lordship, as is clear from the facts, we have a transborder reputation.
Is there any hard and fast rule that everybody should know once you got the patent?
Your Lordship,
there will be a case where people would not have known about your patent, right?
Your Lordship, but that question does not come at all in this case, Your Lordship, very humbly, because Your Lordship, they had asked us for a license of this patent. They had asked us for a license of this patent, and only when we refused to give them the license, Your Lordship, our industrial investigators found out that they are infringed. Your Lordship, this is a clear, that shows the clear malified intent in them. Your Lordship, furthermore, Your Lordship, if we see the fact that to give an order of injunction under Order 39, Rule 1 and Rule 2, Your Lordship, there has to be a note of a prima facie case and towards whom is the balance of convenience. Your Lordship, as is clear here, Your Lordship, we are losing out on our reputation, Your Lordship. The company Bilibili, which has transferred a reputation, Your Lordship, is losing out on its reputation because the defendants are infringing upon our patents and infringing upon our trademark, which is a right given to us by the state, Your Lordship. Therefore, Your Lordship, I would like to also in this matter quote from the judgment of Ringo Infrastructure versus IndiaMart Intermesh and others of the Delhi High Court, Your Lordship. Over there, it was very clearly said, while examining the question of balance of convenience, a number of factors will have to be taken into account by the court, depending on the facts and situations of each case. So, in this case, Your Lordship, we can easily see that we have an import restriction on us already, Your Lordship. Over and above that, the defendants are infringing upon our products, thus causing us massive pecuniary as well as reputation. Your Lordship, I would move on to my second issue and my last.
Is it your case that they are manufacturing very low quality product?
Your Lordship,
I am asking you this question in the light of your argument saying that it is also infringing your reputation in the market.
Your Lordship, we are arguing that from the reason, Your Lordship, that they are managing to sell this product for almost half the price.
In the context of pricing,
in the context of not just pricing, Your Lordship, given the fact that this is a very niche product, Your Lordship. It's a separator. As can be seen from the claim, Your Lordship, this is used in sectors like milk industry and drug industry. And especially given the sensitivity of these two sectors, Your Lordship. Since milk products are used also as baby products, Your Lordship. Medicines are used in the hospitals, Your Lordship.
Okay.
That puts the onus on us, Your Lordship, to bring this matter, since it's not just our pecuniary loss but also our loss of reputation. Your Lordship, the third issue I'm dealing with, which is the second issue as per the problem, Your Lordship, that is regarding the infringement of patent number 42231, Your Lordship. Your Lordship, first, as I have already mentioned, Your Lordship, previously, Your Lordship, that deals with the fact that there was a clear malified intent on the part of the defendants, Your Lordship. As is clear from the facts, Your Lordship, they had come to us asking for a license, and it was around that time when we refused them that the course of action began from their side. Your Lordship, it was only then that when we visited Tuntun Butter's factory to erect a new separator that we found for the first time that our products are being infringed upon by the said defendants. And thereafter, Your Lordship, the industrial investigator, when he did his investigation, he found out that there were certain things which went on to prove to us that there was clear infringement. Which brings me to my second part for because the mode that he used was a simple comparison method. And the Delhi High Court judgment said the mode of such discovery was a simple comparison between the product of the plaintiff and the defendant. So, my lord, the Delhi High Court has already given consonance to the method that was used by my investigator. And further, my investigator has given it on oath by an evidence. My lord, that is essentially, before I go into that, my lord, there is a very famous case, my lord, that is Raj Prakash versus Mangat Chaudhary. My lord, this is the AIR 1978 Delhi 1, in which, my lord, the idea of patent was showed very clearly, your lord, my lords. The effect of grant of a patent is a quid pro quo. In this, my lord, the quid is my ability to give a certain amount of knowledge and disclosing it to the public. And the pro quo is the guarantee that the state gives me